pleasure to welcome Shannon Miller. Shannon is a Florida Board certified attorney specializing in elder law. She practices in Gainesville, Florida. And since 2012, Shannon has worked with the legislature to draft and develop numerous statutes and laws focused on advocacy for many of the most vulnerable members of our community. Shannon served as president of the Academy of Florida Elder Law, currently serves on the Florida Joint Public Policy Task Force for the Elderly and Disabled, and served as chairperson of the Legislative Committee for the Elder Law section, and now serves as vice chair of all of the Elder Law section of the Florida Bar. We are more than honored to have her speak to us today about a very important topic to many of us. And so on behalf of our entire team at NAMI Gainesville, Shannon, we want to express our most heartfelt gratitude to you for sharing your experience and expertise with us tonight. So everyone, please join me in giving a warm welcome to Shannon Miller, our guest speaker.
Thank you. Thank you, Stephen. I appreciate that. Okay, so I'm here to talk about really, can you guys hear me okay? Yeah, okay, good. I'm really here to talk about special needs trusts, and I want to make this the kind of speaking that engages my audience. So I want you guys to ask questions. And I think the easiest way to do that, frankly, is for you to just unmute yourself, maybe raise your hand. And if I don't see it, just unmute yourself and ask your question, because I want this to be something that you benefit from. And if you have something that comes up, I'm sure someone else on the group also has that kind of question. So feel free to interrupt. And I know a lot of you also have questions about other issues besides special needs trust. I know a big issue with many of my clients is guardianship, and is guardianship an option for people who have, you know, a diagnosed mental illness and are stabilized on medications. So we can talk about that too. We could talk about that all day. But I know that's always a question that I get from family members who are struggling with these issues. I am an elder law attorney, and I will tell you that the Florida Bar has literally gone back and forth over the last 20 years, whether or not our section, which is the elder law section, shouldn't better be called the elder law and special needs section of the Florida Bar. Because that is really what we spend a lot of time doing, is working with people who are either vulnerable by their age or by other types of issues. And so what we really try and do in our section of the bar is to work with helping people who fit categories of having special needs. You know, we don't really like to say, you know, I'm disabled. We like to say I'm a person with special needs. And we recognize that everybody pretty much has a special need of one kind or another. And so we just try to make a better effort to represent everybody. So let's start off by talking a little bit about special needs trusts. Estate planning attorneys will often say, you need a special needs trust and you can set it up today. Why not set up a special needs trust for your loved one, and we can start funding it today. It's a great idea. Let's go ahead and do that. I usually don't recommend that, and I'll give you the reasons why. First of all, we're going to talk about the different types of special needs trusts, but the most important distinction is a special needs trust that is set up by the person who is receiving government benefits. So whether that's Medicaid or Social Security, when that person receives assets themselves or generates their own income, we can set up a special needs trust that's called a self-settled special needs trust. Self-settled special needs trust. A self-settled special needs trust has a few very important distinctions about it. It is set up by that individual, so they can set it up themselves. They can actually sign to set it up these days. That hasn't always been the case. And that there has to be a payback to Medicaid upon death of that self-settled person. So if I was in a car accident and now I am completely bedridden, that could mean that I would be on Medicaid for the next 20 years. And when I die, if there are assets left in my self-settled special needs trust, they would have to be paid back to Medicaid. Okay, so that's a self-settled special needs trust. A third-party special needs trust is a trust where someone else is providing the assets for the benefit of our beneficiary, right? So our beneficiary is the one who needs services from Medicaid or from Social Security. They're receiving these government benefits. A third party says, I want to leave money to this person, or, you know, another way that a third party can kind of fund a third party special needs trust is through a different type of trust. So you could actually have like a bigger revocable trust or some other type of trust that then creates a sub-trust or a special needs trust, which is a third party special needs trust. The money doesn't come from the individual receiving the benefits. The money comes from a third party. So rather than giving you statute names and all that federal stuff, I just talk about those two distinctions: a self-settled special needs trust, which has a payback provision to Medicaid. A third-party special needs trust does not require a payback to Medicaid upon death of the government beneficiary, right? So I can set up a third-party special needs trust in my estate plan, and when my beneficiary dies, that person who received those government benefits has now died. Whatever's left in that trust does not have to go back to Medicaid. It can actually go to the people that I named as the third party grantor of that trust. I can say, now I want it to go to their siblings or their kids or whoever it is. So I've been able to preserve Medicaid, and I've been able to preserve, oh, now I'm like, woo. I've been able to preserve Medicaid. I've been able to preserve Social Security. And now when my beneficiary dies, the assets can pass to the people that I've designated to receive them. Okay, so those are the two distinctions between the two types of trusts. Now, there are some other trusts out there we're going to talk for a second about, and one is the pooled trust. The pooled trust. Pooled trusts are trusts that have been established for the benefit of our beneficiary, and they do also have a requirement for a payback to Medicaid upon death of the government beneficiary. There's some other little wonky details about pooled trusts, but I love pooled trusts. I think there's really two of them in Florida that I think are very good. My favorite is Guardian Trust. It's run by an attorney he's amazing. He's a special needs trust attorney, and he has a disabled adult child. I just saw him last weekend. He told me that he's getting ready to start his own group home because his daughter is now old enough and he wants to have that set up for her. So he's just a super great guy, and I trust him explicitly. And he's going to be around for a while. So he understands all the ins and outs of special needs trust planning. And he's also very hands-on with Guardian Trust. Aged is another pooled trust that I've worked with, and they are also good. The nice thing about pooled trusts is that the people that run those trusts, so the trustees are nonprofits. They often do a lot of work giving money back to special needs communities. And they also do some things and have some networking connections that you guys might not have as trustees. So like with Travis Fincham and Guardian Trust, when we put money into that pooled trust, and I say like, our person really is struggling with getting services. Like we can't seem to get our person to agree to do med waiver, or for whatever reason, we can't get them agreeing to do the things that we need to do. And Travis will say, well, we're going to hire a case manager because let's keep family in family roles and let's bring some professionals in and start to, kind of address some of these issues in a more professional way. Excuse me. And what I've found is that that can sometimes be more effective, and it allows us to maintain relationships. Pooled trust fees are not a lot. They're not like bank fees. I think the guardian trust fees are like $1,500 to set it up. I mean, that's what they charge. And then I think there's a percentage-based fee every year that's like 2% or 1.75%. It's pretty low compared to regular trust companies. And there's no minimum amount that you have to put in a pooled trust. The downside is, obviously, that when our loved one dies, the pooled trust keeps some percentage of the money and then but only after they've paid the Medicaid lien off. So the Medicaid lien has to be paid. Okay, let me take a second, drink some water, and you guys give me your questions on what I've told you so far. Or you guys are like, we didn't hear any of it. You have to repeat it all again because it's so much information in such a short time. Or maybe you guys are just super savvy and you already know what I've told you so far. So that's good. Okay. All right. Yes, Leanne.
Shannon, on the third party trust,
Yep.
did you say the third party is who designates the beneficiary after the person that the trust was designated for?
So let's just use names. John
Okay.
Smith, he's got a lot of money and
Okay.
he dies leaving, he had a revocable trust and he funded $1 million in that trust. And when he died, he took $300,000 and put it into a special needs, third party special needs trust for the benefit of Jane Smith.
Okay.
And then Jane lived for another 10 years. She enjoyed a lot of the money, but she didn't really need a lot of it. She didn't have a lot of needs. And so, she tried to use it. Her people tried to use it for her, her trustee. When she died, she had $125,000 left in that trust. Then John Smith, who created the trust, gets to designate who gets it when Jane dies. And so let's just say Jane had kids, or Jane had a sister and brother, and the assets were to be split 50-50 outright upon Jane's death. That's who gets to designate it. Now there's some, technically you want to have what they call an identifiable heir, but there's been some case law. And again, these are like federal cases, so it's pretty set. When some case law comes out, these are federal cases. It doesn't change very much, but this was a big change. If you say heirs at law, that is sufficient to be identifiable. There was some debate before that it should go back to the state if you didn't have identifiable heirs, but now even if you just say heirs at law in the trust itself, that's sufficient. But what we would really like to see, we don't want to use something like, there's this thing called a power of appointment where you can say, I'm going to let my beneficiary decide who they want to give these assets to when they die. We would do that like in a revocable trust. In a normal estate planning type situation, we might do that. But we don't want to do that with a special needs trust because there has to be identifiable heirs. So it's best not to like assign that or leave it open. You need to have some sort of specificity in there. And, the drafting attorney should know that. And so, I always just try to caution people because I can't tell you how many times I've gotten cases where I read the trust and I'm like, well, it has a lot of the qualities of a special needs trust. But there are certain things in this trust instrument that violate the terms of the trust. Yes.
I wonder if you could give a comparison between the ABLE account and the distributions from the ABLE account and distributions from the trust during the lifetime of the beneficiary.
Sure. The ABLE account, which I love, by the way, and you guys maybe know all about that already, but the ABLE account allows a person to park up to $15,000 a year and to a maximum, I think the max now is $100,000. And so the distributions out of an ABLE account during our beneficiary's lifetime, so let's just call her Jane Smith. So Jane has an ABLE account. She's parked some of her, she makes money. She puts some of her own money in the ABLE account. Now the income limits still exist. So you still have to be careful with the income limits. For, you know, if I'm a disabled person receiving Social Security benefits, there are still income limits that exist, even with the benefit of the ABLE account. However, when our people have access to that account, or whoever it is that's accessing the account for our Jane, there is no restriction on how the money can be used. So we don't have to worry about so sometimes we do need to worry about using trust money for food and shelter costs. We'll talk about that a little bit, but the ABLE does not have those same issues. So you're much freer to use ABLE money. And what I like to encourage our clients to do is to like use the ABLE account to save up for something, right? So you can save up for a car, or you could save up for some other thing that's not then going to disqualify you. But I do not recommend storing significant amounts of money in the ABLE account, nor do I recommend that family members make a lot of deposits to the ABLE account, because if our beneficiary dies, the ABLE account assets must be paid to our beneficiary's estate. And who is the biggest creditor in our beneficiary's estate? Medicaid. So even though there's not a direct requirement to pay Medicaid back like there is in a pooled trust or in a self-settled special needs trust, the ABLE account will only pay the proceeds that are left in the ABLE account over to our deceased person's estate. And there's a requirement that we notice Medicaid in every single probate case in Florida, and they will file a lien, they will file a claim in the estate. And so if you have, you know, $30,000 in there and Medicaid's been paying out over, you know, years for our person, that money will be eaten up by that lien. And there's some estate recovery, you know, there's some ways to kind of maneuver that, and negotiate it. But that's one of the things, that's one of the dangers of the ABLE account. Now, if we have a pretty young beneficiary and, you know, like, we don't care if Medicaid gets paid back. The whole point is that they want to save up enough money for a house, or they'd like to buy, you know, whatever it is, you know, we want them to use that benefit. But that's the cautionary tale, is that it will pay over to the estate. And then, you know, Medicaid is a creditor. So does that answer your question?
Yes, thank you.
Okay. Okay. But yeah, let's talk about why these trusts do have these limitations on how you can spend the trust assets. So there's this limitation on food and shelter. All right. Now, before we get too far along here and everyone starts to want to go to bed because this is so boring, I need your focused attention for this part because this is kind of complicated. All right. So food and shelter costs are prohibited because it's a supplemental or special needs trust, right? Except that if you violate the trust by using the assets for food or shelter, the only thing that happens, our person stays on Medicaid. It doesn't affect Medicaid qualification. The only thing that happens is that during the month that you use the trust assets to pay for food or shelter costs, the SSI benefits are reduced by either 1/3 or 2/3. So that's a complicated strategy, but there are a lot of attorneys in Florida that will say, okay, go to Costco during the month of March, blow it out, you know, like buy all your stuff for the year, or do this every few years, realizing that you're going to, you know, notify Social Security that the assets have been used to pay food or shelter expenses, incur the penalty, which would be like reducing your income from $721 down to, you know, $427 or $225. during the month of when you've like done the bad deed, but then you have this kind of, the result usually outweighs the penalty. So we say don't use the money for food or shelter, but the reality is reduction of the SSI benefits during a month or two is usually going to be outweighed by the benefit of being able to use that money for food and shelter for our people, because $700 does not pay for food and shelter. And we all know that. And, then there's this whole problem with deeming, where if we have family members paying for food and shelter for the benefit of our SSI beneficiary, then Social Security considers that to be deeming and may reduce our beneficiaries' benefits based on that. So it's like our people cannot win, because who can afford to live for that? Like, no one can. So on occasion, we will just voluntarily violate the terms of the trust. We'll voluntarily notify Social Security that we've done that and, take the hit and then get reinstated the next month. And some of our people do that regularly. Like, they'll just do it 2 months a year, go to Costco, buy all the stuff for 6 months. I mean, it seems crazy, right? But this is the world we live in. So it's important not to violate the terms of the trust in other ways. But if you violate the terms of the trust by using the money for food or shelter, just notify Social Security, incur the hit. It will not disqualify you from receiving Social Security benefits, nor will it disqualify you from receiving Medicaid. And sometimes we forget to notify Social Security. They'll figure it out, usually, maybe, and then they will incur a penalty. They'll incur the penalty against the assets that are shot out over a certain time period. So I don't know if that's still helpful, but okay. Is everyone still awake? Was that like, are all our minds blown now? Like, oh my gosh, this is so complicated. Yes, it is. It is. And this is kind of the point that I was trying to make earlier about these trusts can be messed up very easily. And so I always caution people, because I fix them so commonly. I'll see one that comes in that an estate planning attorney has done. They kind of wing it. They add in language, like some of the language that you can't see in a special needs trust is that the beneficiary has discretion. Like, the beneficiary can have no discretion in how the assets are paid out. Also, the trustee, can have some limited discretion, but these need to be irrevocable special needs trusts. They cannot be revocable. The monies cannot be used for the payment of creditors. There's a whole host of things that when I look through a special needs trust and I see them, I go, oh no, because when it's an irrevocable trust, it's tricky to amend. So they're very tricky to change. In a lot of the newer versions of these special needs trusts, we'll actually see some provisions in there that can be changed, but they're limited as far as what, like, you can change trustees. You can do some changes that wouldn't affect distributions, but it is very tricky. And so I always caution people, like, just make sure that your person who's drafting it knows what they're doing and understands Social Security. Like, I also have people that come to me and they're like, yeah, I have this special needs trust. And I say, well, let's talk about what your benefits are. And they're not getting SSI and they're not getting Medicaid. They're getting SSDI, they're getting SSDI. And that is, the program where you pay in for 20 quarters, for 10 or 40 quarters, for 10 years, you pay into the system, and it's like paying for insurance, and then you get your money back if you become disabled. So, those are the situations where you don't need a special needs trust. There is no asset disqualification for you. So you can be a millionaire and still continue to receive your SSDI benefits. And so sometimes there's some confusion over that, like, what types of benefits am I actually protecting? And sometimes the answer is, I don't know, because I don't see anything in your records that show that you have assets that you're receiving income that's asset based, which means that you can't have more than a certain amount of assets, $1,500 for Social Security and $2,000 for like the med waiver program. So it's tricky, and we just want to make sure that we're doing the right thing by you guys when we assess these issues and put you in the right type of special needs trust. I mean, I will tell you, a lot of times I get these calls and I say to people, use the ABLE account. And if you guys are not familiar with it, Able United .org has a great website, and they've got a great video about like what the assets can be used for, what can't be used for, but you have to have that diagnosed disability before the age of 26. So it's like 26 or younger, I think, is the age cutoff. So, that can be prohibitive for some people. Okay. What else do we want to talk about related to special needs trusts? Everyone's like, oh my God, it's so hard. Ed, hello, Ed.
Hi, you did mine last year, which is fantastic. Has there been any changes?
I can never disclose, so.
Oh, sorry. Is there any
You can,
changes?
you can.
Is there any changes that are relevant from a year ago that I need to be worried about or anything like that? Okay.
No. You're
It's still good. Okay, because I know its stuff was changing all the time.
Yes.
Designated representatives. This is a tough one for me, because, or it may be for other people as well, when you don't have somebody really that you trust. And did you say there was a gentleman that did that, or was that only through the pooled?
Yeah. So, okay, let's talk about what you mean by designated representative. So, or we're not talking rep payee.
Right.
Okay. You're talking about like, someone who would be like an advocate for our beneficiary if you were
Yes.
not around.
Mhm.
Okay.
Exactly.
Okay. Yeah, it's a tricky situation. And that's why our successor trustees need to be selected very carefully. And so, there are processes in our trust code that if there isn't a successor trustee that's been selected inside the trust instrument itself, there's a process for picking one. But I often suggest to people, like, pick one, pick a successor, pick a second successor, and then have a provision for how another successor would be picked if there was no named successor, or if all your successors became incapacitated or died. A lot of times that can be like, pick a trust protector who can then name a trustee. Sometimes it is use this corporate fiduciary. Maybe it is using the pooled trust or some other trust company that is going to be around that has assets under management that exceed a certain threshold. We usually like to say 100 million in assets under management. That way you're not going to see a bankrupt corporation that you've named. And you also want to put in there like, or their assigns, because sometimes banks buy other banks or companies buy other companies. So, there's a whole bunch of range of ways to kind of address that. But I've actually never had a case where we ran out of trustees or, we had a problem with that. So usually in the trusts I'm drafting, I'm going to have some way of naming successors. And if it is a third-party special needs trust that you want to last for a long time, those considerations become more important. But Ed, that I always say, don't overfund your special needs trust, right? And I say that because we don't want to overfund our special needs trust, because that's taking assets out of your family's ability to use it for good. And I don't believe that that's helpful to a beneficiary who doesn't need the assets. So if we have a beneficiary who is special needs, but they're receiving SSI and maybe they're on med waiver, maybe they are having just in a situation where they're in a setting where they're able to earn their own income and they're able to support themselves. We don't need $1 million set aside in a special needs trust for their needs. You want to look at what their needs are. You want to look at what their potential needs are, and, you know, don't overfund a special needs trust, because it does take assets out of the hands of other, you know, potential beneficiaries who could use the assets. And I have had a lot of cases like at Takachali, where we have overfunded a special needs trust and our beneficiary just never needs the money. Like all their needs are being met, and we're looking for ways to spend the money, because frankly, when they die, it's going to go back to Medicaid. And, you know, we're like buying karaoke machines, and we're like, does everybody want to go to the beach this weekend? You know, can we get everybody together so we can go to the beach, so we can, you know, have the benefit of these assets? Because, you know, if you have assets sitting in there and then we have a payback provision, that's not, then what was the point of doing it? Yeah.
I'll reread the, you know, it's this thing.
Yeah.
It's a lot to go over, and I haven't looked at it in a year, and I'll peruse it and make sure that I didn't. And when you say fund, that means title.
Yes.
Right. I remember you or y'all, hey, this is no good unless you title.
That's right. Got it.
So, yeah.
That's
Thank
right.
Thank
Yes.
you so much.
You're welcome, Ed. But yeah, and that's an important thing. So I'm sorry, Virginia, was I interrupting you? You were going to say something?
It's a different question if you're not finished.
Yeah, no, I'm good.
Okay, I made a mistake and put my river house in an irrevocable trust. It was a mistake.
Mhm.
I meant revocable. Is that, now that I'm still alive, can I change that just by quick deed?
I'd need to look at it. I'd need to look at the trust too, to tell you. Okay, and the reason that I say that is, so there may be some way of doing it that the drafter of the irrevocable trust has created, some method for correcting errors of some sort. And this is really a funding issue. So the question would be, if you funded it into your irrevocable trust and you want it now to go into a revocable trust, which is like something that you can change, we just need to look at the terms of both of those trusts to see if you have authority to do that.
I believe that I did it myself. I didn't have anybody helping me. I just put ear instead of revocable.
Yeah, I still would want to look at it. You know, I mean, people always want me to say like, yeah, you can do it, but man, I'm never going to do that, because
The other question I have about that whole thing
yeah,
is that my dependent son can own his own home. Is that true?
that's true. Homestead is exempt. Yes.
Okay.
But here's the tricky part of it, right? So we can put a home in our disabled person's name, but if they can't make decisions for themselves, or if they like start to do some things that maybe are not good for them, like taking equity out by getting a mortgage, or like letting somebody take equity out and, you know, getting a promise to pay it back and they're never going to get it back. It can be very challenging for us to then, once it's been gifted into our person's name, to manage it, because once it's in their name, they can do whatever they want with it. And if we don't have a guardianship to protect them from that issue, you know, it's a problem. And then let's say hypothetically, we realize that they're not doing well in that setting. You know, they really are not doing well in that setting. And then we have to sell the homestead. And then the proceeds from the sale of the homestead would be disqualifiers. So then we have to do a special needs trust. And it's not the pretty third party kind. It's the ugly self-settled kind, so that when they die, the assets are going to have to go back to Medicaid. So my suggestion would be that instead of giving a house to our loved one, we put the house into a special needs trust. And so it could be a third party special needs trust. And then the trustee of the special needs trust can manage it. They can make sure that no additional equity is taken out unnecessarily. They can make sure the taxes get paid. They can make sure that if that living situation is no longer good for them, then we can sell the property without disqualifying them from receiving Medicaid, without having to put the money into a self-settled special needs trust where the payback has to go to Medicaid. The money just stays inside the third party special needs trust and it doesn't disqualify them. Maybe this time we buy a condo. Maybe we use the proceeds and do something else. It just creates a little bit of protection for our person who maybe isn't really great at making good decisions for themselves. And it gives us the ability to shift as their needs shift. And you guys know way better than I do that those changes come. My normal review of our clients who are in guardianship with mental health issue is about 7 years. We see them come back around about 7 years where they go off their medication or decompensate, and we have to have interventions and kind of everybody dials in. We do all hands on deck to try and help our person, and then we get them stabilized. But what has happened with the wreckage during that time that they weren't doing well? And I always worry about homestead in the name of our person. So does that help?
Yes, thank you.
But your husband is like, wait, I have more.
No, thank you very much. This is all very
Yes.
helpful.
Yeah.
For that third party, in the case you just described, the third party trustee cannot be the beneficiary.
Yes, it cannot. No, because there'll be a merger of the gatekeeper with the beneficiary, and that would be a disqualifying event. And Medicaid and Social Security will be like, wait, no, this is it. The trust must be like, when we think about these trusts, they are separate from our beneficiary. Our beneficiary is only a beneficiary. There's this entity where our beneficiary receives something from the trust, but the trust is separated from our beneficiary. Because once
No,
they merge together, they're disqualified.
I actually meant post-death of the original beneficiary.
Still, no.
Okay.
Because we have to have that separation in order for the government to say that they just don't have the asset. Like there has to be some kind of gatekeeper and something called ascertainable standards for distribution in order for the federal government to consider it as a trust for a person's special needs. So it's very important that we not allow beneficiaries to have any control or discretion over the trust assets.
Thank you.
Sorry, I know that's not a fun one because we want our people to have, really access to it and be able to direct how the assets are used. And that's why we need to be very good at picking our trustees. Like, this should really be about our beneficiary saying, I need a new bed, I need this, I need that. And the trustee writing a check. That's how it should work. And that's how it works with the pooled trust. The process with the pooled trust is like, you make your request or you make your request for reimbursement and you attach a receipt and they're going to send a check right away. And that's how it should work. There shouldn't be anybody like, well, I don't know if that's what's in the best interest of the ward or anything like that. That's not how it should work. It should work that this is completely about the beneficiary's needs. And, it's like, it just flows right through. Our trustees should be educated. Now, if our beneficiary is making bad choices, if they have a gambling problem or they have addiction issues, our trustee can also be the gatekeeper and say like, nope, we're going to hire a social worker to help you with this stuff. But yeah, it's important that we have some balance in that regard. But yes, we want it to be like not some banker in a building looking at trust terms and saying, well, I'm going to make more money if I keep more money in the trust. Like, that's not the kind of trustee that we want. We want a trustee who actually is trying to get the money out in the hands of our person. And that's why we use
I
really.
just have one clarification. Does that mean that, say, a brother-in-law would not be a good choice or can't be a choice?
I think a
Because
brother-in-law is
he
great.
not a brother-in-law.
Well, I mean, even a brother might be a good choice. We often do that. We often have siblings, you know, and it's really up to you as the creator, like the grantor or the, you know, the testator, the person who creates the trust. It's really up to you to pick that person, but you want someone who's going to be able to say no. You know, if they want to use all their money on video games and you're recognizing that this has really become an addiction issue and it's not helpful, they need to be able to say no. But then also, we don't want that person to say like, well, when they die, I get what's left, you know?
Yeah.
So,
That's my question.
Yes.
So that brother-in-law could not be a beneficiary of my will
Mhm.
or that. money.
nah, I mean, I don't know. The families that we usually have come in, like, they don't care if they get a dime. They want their sibling to be properly cared
Yeah.
for. But it depends. It depends on your family, and it depends on, you know, the spouses of your, right? Yeah, everyone's like, yep. I mean, it really depends. And we do have some professional guardians in town. We have some good geriatric care managers who can, you know, some of them are willing to serve in those roles, but they're just like everybody else. They can get older and incapacitated and die. So, you know, you can find really good backup people, but just remember, you always want to keep your eye on them. How are they doing?
Yeah,
And potentially have a backup to your backup.
thank you.
Sure. Did you have a hand? Okay, go ahead. I'm sorry.
I think I'm unmuted.
You're good. Yeah, I can hear you.
This sounds really simplistic, okay? But do you have a glossary of terms that it might be very helpful? Because
I'm good.
I'm taking notes and I'm not sure I'm getting it right, like
Yeah.
trustee, beneficiary, yada, yada. So
Right.
is there like a simple glossary of terms?
I should make one. I really should. What term, like, okay, yes, let's talk about some of the terms that I'm using. Like grantor would be the creator of the trust. And what I probably should be saying is creator of the trust, right? But it's also the person who has the authority to authorize the creation of the trust. So in some circumstances, it's usually the third party grantor. So that means that the funds are coming from someone other than the beneficiary, who's the person who's receiving government benefits, right? That we're trying to protect.
That's the beneficiary.
That's the beneficiary. But there can be other beneficiaries. That's our primary focus with a special needs trust, is to protect the qualification of a Medicaid beneficiary and an SSI beneficiary. Those are really the two reasons that we need a special needs trust. And the other, you know, distinction in that idea of Medicaid is Medicaid waiver. So Medicaid waiver is a program that provides like $60,000 to $70,000 worth of services a year to adults with disabilities that are normally developmental disabilities. So when I talk about med waiver, I'm talking about people who are receiving significant support on an annual basis, and they really need those special needs trusts because it's not just covering their medical expenses when they go to the doctor, it's providing literally their life. And it's like a 2-year waiting list if you get disqualified from the med waiver. So grantor is the person who creates the trust. Sometimes it can be the person who receives the government benefits. That's a self-settled. But in those cases, the grantor is our beneficiary. It's our person receiving benefits. But a third party special needs trust, the grantor is going to be someone other than our person who receives government benefits. Does that help, Joan? What other questions? Irrevocable versus revocable?
Yeah. I mean,
Okay.
sure.
Right. So irrevocable it's like, we can't change it.
Right.
But
think I mean,
There's always a but, right? We do have a way to change irrevocable trusts in Florida. There's actually 4 different ways to change irrevocable trusts in Florida. And some of them don't even require us to go to court. We can do these things called non-judicial modifications of an irrevocable trust to fix things. So if you guys had a trust that was irrevocable and it's a special needs trust and you're like, oh no, no, we can fix it. We can fix it. And we've done that on a regular basis. So even though it's irrevocable, which means it can't be fixed, it can be fixed. We just have to jump through some hoops to get that done. Revocable means that by its very nature, it can be changed at any time. It can be modified, assets can be put in, assets can be taken out, which is why I always like kind of when I hear like, let's take assets out of an irrevocable trust, I'm always like, whoa, whoa, whoa. We want to look at it and make sure that that would be something that we can do. And like Virginia, one of the reasons that I especially am like, whoa, with that, because when we're dealing with real property, if we create a title problem, which means that when someone goes to buy the property later, they see that there were these 2 deeds that kind of came into the trust and went out of the trust. And like, for example, if the trust wasn't recorded in the public records, so they don't know what the trust says, it can create a defect on the title. And then a title company won't insure the title. And so then you have to like open an estate and open another estate because you guys have already been dead for 25 years and we can't fix it. And so it is really important that if we're going to do things that affect real property, that we do it properly and make sure that we haven't created a title defect. So it can be, that's why I'm like super cautious when we're talking about changes to an irrevocable trust or doing things with real property. We want to be very careful with that. Okay. What else, Joan?
I was thinking that a special needs trust was only accessible to the beneficiary. The funds were only accessible to the beneficiary after the grantor dies. So after my husband and I die, then my son would be able to access the funds. Am I mistaken in that?
No, you have it right in most cases. So in most cases, and I'm going to make this even more like we need to add this to the glossary, but what you're mostly talking about is the very common type of special needs trust, the most common type. It is a third party testamentary special needs trust. And testamentary means that it becomes effective on someone's death. So it's like it either becomes effective in a will or it becomes effective in a trust. So it sits dormant. We don't have to get a tax ID number for it. We don't have to put it in a bank. We don't have to pay fees on it. Those are my favorite types of third-party special needs trusts. They sit dormant until we need them. And if our person like predeceases us, I mean, we hope that never happens, but if they do, then there's usually a provision in my will or in our trust instrument that says it's going to skip that person now. We don't have to fund that special needs trust. It's there if we need it, but we don't have to, go through the trouble of establishing it if our person passes on. Now, with regard to like this idea of a non-testamentary third-party special needs trust. So this would be a trust that is created today. We can do that too. And the reason that we might want to do that, there aren't a lot of reasons that we want to do it, but one of the main reasons that people do that is for the reason that Virginia was talking about earlier, like we might want to have a home that goes into that trust today so that we are still alive while our person is figuring out how to live independently, right? We want to see how they do with that. So we might decide, I want to set up this trust today. I don't want to just do it later. I want to set it up now so that I can be here when our person doesn't do well or when they do well. And I can be like, hooray, I don't need to worry about this anymore. And I can take it off my worry plate. So that would be a reason that we might want to set up a third party special needs trust that is immediate. Now, what are the downsides to doing that? there are downsides. It's an irrevocable trust, and you can set them up like today, but they will be taxed at a higher rate. So if we weren't having the income of that particular trust move out and be able to be credited to someone, if the monies just stay inside that special needs trust, the income that's generated inside of it will be taxed at a higher rate, a tax rate instead of your personal income tax rate. So there are some downsides to setting up an irrevocable special needs trust now, as opposed to when you die. That still happens, but usually the income is going out and they can declare it on their own personal taxes and have the benefit of a lower income tax rate by pulling the money. It's like a conduit, it just flows through. So that was a lot more definitions than you asked for. So
I would love to have it literally,
I know
in
you like
glossary
it.
form.
Yeah,
But
I'll think about that. I think that's a
here's-
very good idea. I'm gonna write that down.
You could
Glossary.
have a book title, I'm just saying.
I know. And then we could just flash it up. Let me do one thing though. And I know I have the share screen option. So I am going to just flash up, and I don't know if we, okay, wait a minute. Let me just get to my spot. I want this. Okay. I don't know if we circulated the, here we go. I don't know if we circulated this yet, but this is the Medicaid Basics worksheet that we hand out. Someone or many of you on the screen might or have already seen this. It gets updated when all the new numbers come out. But this can be like a handy little tool because it really addresses a couple of things. It addresses what Medicaid qualification looks like. And that's on this first page. It's like you have to be a US citizen, you need to be a Florida resident, 65 years or older. These are all the criteria for qualification for Medicaid. And this is really geared towards our seniors for long-term care placement. But really the criteria is the same. But for most of us probably on this call, I would say the Medicaid is going to come with SSI. So if our person is getting SSI, they're also going to immediately get qualified for Medicaid. So that's just, one less thing that you guys have to worry about. But all of these things could, if you violate any of these, they could disqualify our person. And then if we look at this second page, so this is all just really stuff down at the bottom is probably not that applicable. But if we keep going down here, we want to think about some of the things that are not disqualifiers. So these are assets that are not countable. And one of them is the ABLE account, homestead, we've already talked about. You can have one automobile and a second automobile that's between 7 and 25 years old. You can have a prepaid irrevocable funeral policy. You can have a CD or savings account with up to $2,500 in it. You can have enhanced life estate deeds, although I wouldn't recommend that for the reasons that we talked about before. But then as we move down, we can kind of see how does this overlap with SSI and SSDI. And so, basically it's the same asset and income requirements with a few variations. And so you can see on page 4, which I'm sorry, this is like a lot, but we're just going to move on down here. This is the SSI qualification criteria. So you can see that there's a couple of differences. You can only have one automobile. You can have a special needs trust. Life insurance has to be worth $1,500 or less, whereas with Medicaid, it's $2,500. And so this is some of the differences are pretty well delineated in this little handout that I think we're going to send to you. If you haven't received it already, it'll be in the mail. And then this page 3 really goes into a little more detail about, I'm sorry, this is this page right here, which I think is page 3, even though it says 1. But this goes into, you know, the different types of special needs trust. Self-settled special needs trust. You know, if you hear an attorney, they'll always call it a D4A trust. These are federal statutes. And then we have our D4B trust, which is a qualified income trust. And then we have a D4C trust, which is our pooled trust. Then we talk about third-party special needs trusts that are the ones that don't have to pay Medicaid back. And so that's really kind of what this this handout is intended to do. And one thing as well about this handout, and I just, it's overwhelming if you really try and drill down into all this stuff. I just say, keep it handy and look at it as you need it. But on the back here, this kind of gives, I think it's kind of a cool little overview of what is Social Security disability, SSDI versus Medicare, SSI versus Medicaid. And this kind of explains all of those differences. So I think this can be very helpful if you just kind of look at it in small doses. Okay, Leanne, I see you have your hand raised. But you're muted.
Got it. Can you hear me?
Yep.
Yeah, I frequently do that. I wanted to piggyback on Joan's last question, but please leave this up because I really like this.
Okay.
Is this the handout that Debbie
Yeah.
sent us?
Yes.
Fabulous, because I
Yes.
need that. Okay.
And let me just say also, when we update it and we put it on our website. So
Excellent.
if you guys ever lose this, or you're like,
Okay.
I can't find that thing, just go to the Miller Elder Law Firm, hit
Okay.
link, and it'll say Medicaid Basics, and it should have the most up-to-date version because the
Okay.
numbers are updated about every 6 months. So we just
Okay.
try to keep that updated.
Great. Piggybacking on Joan's question, and you mentioned, if I wrote it down correctly, about the testamentary special needs
Yep.
trust.
Yep.
That's effective, like Joan was saying, if her and her husband passed, then it becomes into effect, etc. Okay. My situation, if I had one of these for my loved one who is actually older than me,
Okay.
so let's say I passed away and but I do not trust my loved one to be able to manage money.
Yeah.
They haven't exhibited it, etc.
Yeah.
How do I designate or make a third party testamentary special needs trust and have it have, what do you call, I don't know if it's called a guardian ad litem or a trustee of it that actually will determine, because this loved one will manipulate like crazy
Yeah.
and is very skilled.
Yeah.
So I mean, I would only make that trust because I want that person to be able to have food and clothing and things like that, but not obsessive things, because there's an obsession issue.
Yeah. So my
So-
suggestion,
Mhm.
pooled trust. Pooled
Which
trust.
trust?
Pooled.
Pooled trust. Okay.
Yeah. Using the pooled trust because nobody pulls one over on them. They do it.
I like that play.
What they do is get boots on the ground, you know.
Okay.
So they have usually a case manager or a licensed clinical social worker who's in the area who does this, or a geriatric
Okay.
manager if our person is older, and they just check on them, you know. Like we had this social worker, and our like grandmother was like a hoarder, but she wasn't our beneficiary. It was our granddaughter.
Mm-hmm.
Like her bed was on the floor and like she didn't get the benefit of any of these services that we were supposed to be providing. So we had our social worker kind of become the, you know, like the carrot and stick, like we're not going to be giving you any more money unless, you know, these things happen.
There's an improvement on the other.
Yeah.
Okay. Got it. Okay.
So, I mean, sometimes it can just be a matter of, you know, letting these professionals who do this stuff on a regular basis, like do it.
Okay.
And, you know, there's a fee for that, of course, like the social worker
I'm
has
sure.
to be paid. But in the end, like, you know, if that person who you treasure needs Medicaid, right?
Mhm.
For long-term care, like let's say they develop dementia or Parkinson's, or they have hit their head, or they, you know, whatever, they get in a car accident. These assets will be available to be restricted so that they can qualify for Medicaid long-term care as well, because that's like already sheltered in that pooled trust setting.
That's a Medicaid waiver, correct, for the long term?
No, that would be like Medicaid, institutional care placement, or ICP Medicaid. So it's like a
Okay.
little bit different. Don't
Okay.
worry too much about that. Don't worry too much, but that is mostly for like 24-hour care type, nursing home type situation.
Okay, thank
Med
you.
waiver might be an option as well. You know, there is a little wait list for med waiver. If you're just talking like assisted living or maybe home community-based services. But I don't want to get you guys overwhelmed with info, because
No, I understand. Thank you.
you're gonna die. Don't get overwhelmed. Okay. So yeah, I mean, I think probably using like that type of scenario. I mean, the other option would be not, maybe if your person doesn't have benefits, like, does your person have
Mhm.
benefits? They have benefits now?
Just Social Security, Medicaid. That's
Okay.
it.
Okay, so getting SSI and Medicaid. Yes. Okay, so that person is getting benefits. So we want to
Yeah.
keep that, because that's important for our person. So the pooled trust is a good option, or using, you know, some other type of professional trustee, or like a professional guardian. We've used them before as well. But it's hard, because what if that person dies or closes up shop, or, you know, it's kind of nice to have an entity that's going to have continuity.
Yeah.
Why I like nonprofits, because you know they're going to keep going despite the people. So you kind of have some faith that there's going to be sufficient duration of a trustee,
Yeah.
but you also want to be careful with that too. You've got to have some provisions in there that just in case they don't, then
Yeah.
what happens? You know,
Yeah.
so just through the drafting, you can address those issues.
Okay. Thank you.
Yeah,
One other question.
sure.
Special needs trusts. This has put you on the spot.
What do they
People are
cost?
concerned about the cost.
Sure.
I'm sure there's got to be like a bracket, and I'm sure it's not
Sure.
identical for everything. I know it's got to be man hours, woman hours, whatever.
Well,
You know what I mean?
yeah, actually, we do charge flat fees. And it
Really?
depends. Here's what it depends on.
Okay.
If we have to go to court to get court approval to establish them, they
Okay.
are running between $2,500 and $4,500.
Okay.
For like a regular special needs trust. Now, if
Okay.
we're doing your estate plan and we're just parking a special needs, so if you guys came to me and were like, I don't have any estate planning, but I have a disabled person that I want to provide a special needs trust for,
Mhm.
I'm either going to put you in a will-based plan, or I'm going to put you in a trust-based plan, depending on your
Okay.
assets, whether you're in a second marriage, you know,
Okay.
all the good stuff that I need to know about you and your assets. Like, are you in
point.
an estate tax situation? Do you have other beneficiaries who we also need to worry about because
Mhm.
they're in shaky marriages, or, you know, for whatever reason, we need to like look at whether or not we need you in a trust-based plan or in a will-based plan. Then those plans will change, you know, that's going to be an additional cost. But
Okay.
all I'm doing for you guys is setting up a third-party special needs trust, or I'm setting up an immediate special needs trust today. It's going to run you between $2,500 and $4,500. But if we're going to do a full gamut of estate planning, meaning it's like you and your spouse, and we're going to fund your trust, and we're going to record deeds, and we're going to do enhanced life estate deeds, and we're going to do all these things to get everything ready, that's going to run you between $4,500 and $7,500.
Gotcha.
And you guys can get it cheaper. I never want to discourage people from shopping around. Just make sure they know what they're doing. That's my only caution. Just make sure,
Thank you.
take some questions from what we've talked about today and like ask them, you know?
Thank you for your candor.
Of course, of course. And, you know, I mean, the reality is being an educated consumer serves everyone, you know, because even for that attorney, maybe who doesn't really know what they're doing, if you come in as an educated consumer, they may be like, I'm not going to wing it. then maybe they're going to go back to school and try and learn how to make sure these things are done correctly. Like we just had one where my poor man, the wife died. And the husband, we had to do some litigation to fix because the attorney here didn't address the estate plan in another state. It was very complicated, but he spent like $15,000 fixing it. And so we had to go back to that attorney and say, like, here's the bill for $15,000 because you committed malpractice, and that attorney had to pay $15,000. Now, if at the beginning, when he took that client in and didn't know what he was doing and tried to wing it, maybe next time he won't do that. So, you know, that's the thing, is like, if you have questions, it's helpful to the attorney too, to know that, you know a little bit, and that doesn't sound right. And maybe they'll pause and think like, maybe I'm outside my wheelhouse right now, and maybe I don't want to jeopardize someone's Medicaid. Like, help that, please. Because it can be a lifesaver for people. Like med waiver. If you get disqualified for med waiver and you have to reapply, you have to get back on the wait list, and the wait list is 2 years. So if someone messes up your Medicaid and all of a sudden you get a disqualification notice because an attorney didn't know what they were doing and they did it wrong, you're going to have to get your application back in and sit on a wait list for 2 years. And, you know, our person has all these services. They've got their case manager, they've got their behaviorist, they've got their group home placement. Like they cannot afford to not be in there for 2 years, you know? Right. So yeah, it gets me a little fired up. So I'm sorry about that, but yeah, good to be educated consumers and shop it. I mean, because in the end, you know, it is money that you guys are likely going to take from our government benefited person. Like, you know, you're going to use this money to set this up properly for this person. That's less money that you're going to park in their assets. So be an educated consumer, try and be economical about it, because we do want to give them as much as we can, you know, just make sure it's protected.
Thank you very much. Appreciate it.
Yeah. Okay. What other questions? Sharon, I see you there and you have not asked any questions, but I feel like you might have a question, but you're muted. You're still muted. I don't know if Stephen can unmute you, maybe. Oh, wait. Oh, you guys both hit the button at the same time. You're muted again. Still can't hear you.
It keeps going.
Yes, you got it.
Why is there? But you said that you're going to send that to us in email, or
well, Stephen is going to send it and Leanne is going to send it. One of them.
Okay.
Yeah.
And how do we get a hold of you if we should want to? I mean, this is something I need to get clarity and solve, so I don't wake up at 5 o'clock in the morning and worry about this.
I'm going to put our phone number in the chat. Okay. To our firm. And that is the best way to get on the calendar. And both Jenna Fasulo Lapierre and I, and now we have another attorney doing Medicaid. Well, she's so new, like she probably won't be doing any of these phone calls, but eventually she'll get to the point where we're going to have 3 attorneys that can do all of this for us. But our website is millerelderlawfirm.com. And one thing that I would encourage you guys to do, just because this was so much information in such a short period of time, go on millerelderlawfirm.com and review some of the videos that are there. And then go to our YouTube channel. And this is so corny, but the fact is, with social media today, you can peruse our YouTube channel and basically catch one of the lectures that I've given on this topic. And it's the same thing that I've just said to you guys. So I repeat it again and again, so I don't forget any of it. But usually I find that our clients, it takes about 3 times hearing this stuff. And I bet Ed would say that he agrees with that, you know, it takes a few times hearing it until it really, you start to understand. And, you know, Joan, I appreciate the idea of a glossary that should be added to our next redo of our website, because we're going to do that because it's important. It is hard. Lawyers tend to talk like lawyers. And so I apologize for that, but I think it's a great idea and I'm gonna put that in the hopper.
And I
Um,
want to say,
You're
we also have oh, sorry. We also have been with you to get our special needs trust set up. I'm saying that as a wholehearted endorsement. Just wanted to say that. So,
Thank
okay.
you, Joan. See, I take attorney-client privilege very seriously, but I appreciate you sharing that. It's very nice. Okay, Sharon, did you have something else you wanted to ask?
I saw, as soon as I saw that you had the phone number up at the top, it was gone.
I'll do it again.
All right, thank you. I'm sorry, I'm slow. I just been looking
Don't
at the right.
worry. Okay. Any other questions about anything? Because I'm happy to talk about guardianship and the difficulties of guardianship. I do have to jump off at 8, but happy to talk about that if you guys want to. It's hard. Anybody need that or other issues? Because we can talk about anything.
Can you touch on guardianship real quick, just so, if that's all right?
Absolutely. Absolutely. But I see Monique has her hand up. and
Oh,
so-
go ahead then.
Yeah, let's get to Monique. I'm sorry, Monique. Go
It's
ahead.
okay. Thank you so much. I'm glad to be here.
Good.
I have a question. I have elderly parents who are in their late 70s, early 80s, and I know they have done their will. I have a sibling that has a disability and receives SSDI.
Okay.
So would you say that it would be important for my parents to take whatever will planning they've done and put something in place for the benefit of my sibling that might need some
Yeah,
assistance, just in case something happens to the other siblings?
Yeah. So the thing about it is so SSDI, if that's all he's getting, is not, he won't be disqualified from receiving those assets. So if he's not getting SSI and he's not getting Medicaid, then SSDI with Medicare, he doesn't need a special needs trust to continue to get those benefits. He could receive $1 million from them and his assets and income will not be reduced because SSDI is not affected by how much you have. Does that make sense? Okay.
It does.
yeah.
Thank you so much. So they don't have to put any special provisions in place because my sibling is actually a sister, will still get what she needs. Okay.
But
Now, what if they want to, give her money?
let me drill down into it just a second, because sometimes people think it's SSDI, but really it's SSI and a little bit of supplemental SSDI. So she may be getting both. So the important thing is to look at that Social Security notification that comes out and see, and usually it's going to be delineated by the value. And I'm always like looking for like $730 or whatever the amount is. And that's going to tell me they're getting SSI. And if she's getting Medicaid, then you know she's getting SSI. So find out first, because then it is income and asset based. So just figure out for sure that she's getting only SSDI and Medicare. But if she's not, if you look at it and you're like, oh no, she gets Medicaid, here's her Medicaid card. And she's paying no co-pays, like everything is 100% covered, which we know doesn't happen with Medicare. Then that can also be an indicator that she's getting SSI and Medicaid. Okay, so that's the next thing. And then your question is like, so what do we do if she is getting SSI and Medicaid, and then she needs to have a third party special needs trust in the will? And they may already have that. So if they went to an attorney and they said, we have a child who has special needs or who receives SSI, hopefully that attorney drafted a third party special needs trust in their will. And if they're private people and they don't want to show that to you, that's fine. They can also call our office and we do free reviews. So if they want to send us their documents, we review it for free. We set a phone call and we'll say like, I had one yesterday. I was like, you don't need it to change anything. Everything looks great, and you're good. So, this attorney that you had did a really good job, and we don't need to, we're fortunate. We just don't need to change people's stuff when they don't need it changed. So, just have them call us, or anybody really. The most attorneys in town that do estate planning will review your stuff for free.
Thank
Okay.
you so much.
All right. But but if, let's say hypothetically, she's only getting SSDI, she still might want to have what's called, okay, and Joan, don't kill me, but I'm going to mix the names now, but still might want just a testamentary trust. Yes. Which isn't going to be special needs. It's just, Monique, it's going to be a trust where some of you guys, the siblings, are the gatekeepers for her, so that, because you guys know if she gets a bunch of money, it may not be good for her. And so to have somebody who can be a gatekeeper, that's really important. And it's easy to do in just a regular old testamentary trust. It can be done inside of a will, and it can also be done in a trust, but it doesn't have to be complicated. It can just be like, here's the trustee. They have total discretion. And what I mean by that is that they're the gatekeeper. They can let the money in and out as needed. But if she starts using it for wacky stuff, they're like, nope, we're not doing that. You can have the money for X, Y, and Z, but we're not spending it on gift cards to send to scammers. Nope, we're not going to do it. So yeah, I hope that's helpful to you.
It was. Thank you so much. That's a good starting place.
Okay, good. Okay. Quick overview of guardianship for people with mental illness or with a diagnosable mental health disease. May I call it? Yes, of course. Okay. So, this thing about guardianship and mental health issues, the bad news is it depends on the judge. If you have a judge who's reviewing incapacity proceedings, like we have right now in Alachua County, who's she's a magistrate and she's so good on mental health issues. She gets it, and she's going to do an incapacity guardianship and we have really good evaluators. So we have Dr. Warner, who is a really good mental health examiner. And we have two nurses that are really good, Karen Reed and Tony Ratliff, who are very familiar with mental health issues. And they're often going to recommend an incapacity guardianship. And so we can get them right now. And so it's good, even if we have people who are stabilized on medications. And it's a less restrictive alternative. So oftentimes what we can do is create something that may not be like a full taking away of a person's rights. But instead we say things like, you know what, Judge, she's capacitated and stable right now enough that we want, she's done a durable power of attorney appointing a family member to make financial decisions for her. We want an order of incapacity, but we want to use a less restrictive alternative of a durable power of attorney. And then the judge recognizes the durable power of attorney document as being lawfully executed. They still have an order out there that says our person is really incapacitated, but this is a less restrictive way to help them protect themselves from, decompensating, going off meds. When that happens, then we have this durable power of attorney person appointed that is court ordered. And so we're pretty safe in doing things like that right now. That can change tomorrow. But for right now, it's really great. Now I've had situations like a few years back, unfortunately, I had a client and his daughter was the guardian, and he died because the judge, well, it's not because of the judge, it's because of these terrible diseases that our people have. But this judge would not enter an order of incapacity because he felt like when he was on his medications that he didn't need one. And then when he went off his medications, we couldn't find him. And then, he died. So it was bad. So when we have the ability to get it done, if you've been thinking about it, now is a good time. And I do like doing them when we have stability. But sometimes we have to do them when our person is not, and we can do it during those times too. That makes it a little bit easier. Our judges are way more compliant in those regards, but yeah, it's hard, you guys. Really hard. And, I know enough about your stories. I don't have any personal experience in my own family with it, but I hear enough from you guys to know how truly challenging it is. And you guys are the real heroes. Thank you.
Thank you.
Yeah.
Thank
Okay.
you, Shannon.
You're
On
welcome.
behalf of NAMI Gainesville and all the people here this evening, we'd all like to express our appreciation to you to take the time and help us to help our loved one and make some informed decisions.
Absolutely.
So thank you so
All
much.
right, you guys. Be well. Take care.
Thank you. You too. Thank you, everybody, for joining us tonight. I hope you all got a lot of information. I know it's a lot. And sometimes it's a lot to write down and I have to rewrite it and rethink about it, but thank you. And I hope that you got something that you found very beneficial. Thank you for joining us.